Good afternoon, and thank you for joining us for today's installment of Saul Sessions and our last installment in this series. We're thrilled that you joined us, and if you're coming back for a second or third or fourth or fifth episode of Saul Sessions, we really appreciate your time and attention. We know everyone has a busy schedule. So I'm really excited today to be joined by my partner and friend, Kaylee Kielty. And what we're going to be talking about today is addressing and mitigating litigation risk. So as a compliance attorney, especially if you've worked with me, you might wonder, why are we going to be talking about litigation? I work with a compliant cannabis company. I don't have to worry about litigation. As we'll get to in some of our conversation today, even the most compliant cannabis operators out there need to understand what litigation risk is and need to understand how to mitigate it. And litigation doesn't just involve disputes between competitors, but can also involve disputes with regulators, as some of you might unfortunately know. So with that, I want to dive right in. Kaylee, I'm thrilled that you could join us today.
Yeah, I'm happy to be here. I will just quickly introduce myself. So I'm Kaylee. I'm a partner in our Baltimore office. As Jonathan said, everyone hears First of all, no one likes to deal with lawyers to begin with, right? And then people really don't want to deal with litigators. And my goal today is to just make everybody be like, okay, she's not that bad. I would talk to her. And most people don't want to talk to litigators because they hear litigation and assume a big, huge court battle where everybody is fighting and it's super expensive and there's a lot of money spent and it's just something everybody tries to avoid. And while that can be the case sometimes, it's not always the case. And it's really not the case for what I do in the cannabis space. So in terms of litigating cannabis risk, I do lots of different things. Primarily, I assess antitrust risk and can do some trainings and stuff in that regard. But also, as Jonathan said, I deal with enforcers when enforcers are poking around thinking that there was a violation, there could be a violation, or just, want more information. So another example of something that litigators can do for cannabis companies is occasionally you might get something called a Public Information Act request. So a PIA request is when the state wants to turn over documents that you've provided them, right? So if you're dealing with a regulator or your cannabis commission, and somebody wants information relating to your application or your change of ownership or any of those types of documents, somebody would file a PIA request with that organization. So what I do, and I do this a lot, is if a client gets one of those requests saying, we want to turn over your information, you can call your friendly local litigator and we can reach out to say, look, we're not comfortable with you providing all of these documents. What are they really looking for? Can you only provide these documents? We will provide you redactions of these documents. We have X amount of time to kind of narrow the information, hide certain information, mark it as confidential. So that's a situation where you did nothing wrong. No one is targeting you. No one is after you. But you may want a litigator to go in to try to advocate for you to try to narrow your exposure or the release of certain documents.
Right. So Kaylee, you've given our listeners, our attendees, a good few examples of, what you might engage a litigator to do beyond a dispute. You mentioned, compliance and enforcement, right? So you and I work a lot in the state of Maryland together. So our regulator here is the Maryland Cannabis Administration, the MCA. Could you drill down a little bit or give an example of, let's say a business wants to do something. They want to advertise, or they want to engage in a transaction, and there's a set of regulations. Let's drill down a little bit. What's a situation where an operator is following what they think is the rules, and then the regulator thinks that they have a different version of history? Kind of talk to us about what you would do in that situation.
Sure. So there's two examples that come to mind off the top of my head that I've dealt with in the past. So both deal with advertising, but two different kind of scenarios. So in Maryland, there is a statute that says you can't advertise, obviously, to minors unless 85% an event sponsorship, unless 85% of the population or the anticipated attendees are over the age of 21 based on like reliable data. So you were talking about strict compliance. Most people would be like, I follow a strict compliance policy. This event serves alcohol. It's obviously targeting, people over the age of 21. We are going to do this event. Well, the Cannabis Association may read that statute differently, and particularly turning on the availability of current and reliable data. So people will focus on sometimes what the language says, and it may seem on its face like it's very clear to one person, but regulators may view it differently. And then you anticipate no dispute, you go forward with your event, and then it later turns out that the regulatory body or the enforcer had an issue with your presence at that event. Another situation that I've dealt with in the past is dealing with logos and images that a cultivator or a manufacturer will put on their products. So how they advertise those images and whether or not it meets certain regulations. And I've had situations where people submit, ahead of time, like, is this logo approved? And they submit it through the process that they believe is correct. And they receive an email back that says, looks good. Do you have any more? Or something that to them seemed like an affirmation and a confirming email saying that they were okay to proceed. And then it turns out that later the commission or the regulatory body comes back and says, this is targeting to children. We don't like the name. We don't like the colorful artwork. You need to resubmit this. And then it becomes a battle as to whether or not that email was accurately conveyed approval, whether or not the regulations were followed appropriately to obtain approval. And it's helpful in those situations just to have a litigator who is used to making the arguments for both sides as to how it should be interpreted.
Yeah, and I think, look, our attendees probably understand this better than anybody else, but what we're getting at, it seems, tell me if you agree, is you can have a set of regulations and you can have guidance documents and you can have instances of competitors doing certain things, but in a new emerging industry like this, even though it's an established industry and has been in Maryland for many years now, things evolve every single day, and it's interpretation. I mean, that's really what we're talking about here, right? And so to me, when I say to you, Kaylee, our client called us and they have this issue, and I think you would be perfect to handle it, a lot of it comes down to, is the interpretation that the client had or that we had on their behalf, is that the correct interpretation and the one that complies with the spirit, if not also the spirit and the letter of the law or the regs, right? So I think a lot of what we're talking about here is how the regulator is interpreting something versus how our clients are interpreting something. Is that how you would see it?
Yeah, I think that's exactly right. And I think it's helpful sometimes to have somebody come in and say, well, this is how I would interpret it. So as a lawyer, this is how I would look at it. I agree with you, or I think it might be a little bit closer to how the regulator or the enforcer is interpreting it. And then in that situation, you've assessed the risk and you can use a litigator to go to the next step to try to, as you said, mitigate the risk and handle any sort of financial or otherwise penalized violations and fallout.
Yeah. And, one of the reasons that I think I work with you as much as I do, and other practitioners in our cannabis group work with you as much as we do, is because you come up with creative solutions to what others might seem as a pretty obvious outcome. So I'm thinking of a situation where, let's say, a client has a violation on their hands, right? They don't mean to violate, but they did something wrong. Employee maybe went rogue or just did something that they weren't supposed to do. Let's just, leave it there. But give our attendees a sense of, okay, something happened where it's seemingly on paper a pretty clear violation of the rules. What's something that you might do? Why would someone want to engage you? Or what, I guess, what strategies might you implement where you're going to talk to counsel for the regulator? Like, what are you going to do for them versus them going to the regulator and saying, you're right, we screwed up, kind of tell us what we need to do? Like, what's the difference?
Yeah, well, right there, you said if they go and say, you're right, we screwed up, that's an admission of liability, right? Whereas if you have counsel, we can go in and negotiate and say, look, my client doesn't think that they did anything wrong here, or like, this isn't how we read the statute. We can go to a hearing, we can do evidence, I can put your witnesses on the stand, or we can try to resolve it. And one thing that I really like to do is I talk to the client first and say, what's your concern here, right? And actually, I can't even say that because it really does vary. I've had situations where somebody has had $1,000 fine and they're willing to go to the mat because they don't want that mark or the risk of becoming a repeat offender if something happens down the road, and they don't think they're in violation. So they really want to fight that $1,000 fine and that, notation of your first violation. I've had other clients who are really concerned about the financial penalty or the fine that's being assessed, if it's in the, $5, $10, $15, $20,000, because a lot of the businesses operate with strict cash budgets, and that's a lot of money to a lot of different businesses, and they don't want that type of financial liability. So I will negotiate, a consent order with the state that has a lower fine for maybe a broader, violation record, saying that you won't do certain things for the next 6 months, 9 months, 10 months, 12 months, whatever it is. So I think that's where one of our greatest strengths here is that we really assess what the client's concern is and how to get them in the best situation that they can be if there was an inadvertent violation or something that we don't want to take to an adversarial hearing to try to fight. We kind of pull the different levers to see where we can come out to best suit the client.
Right. And I think something that you're hitting on that's very important, that's worth, just pausing on for a second, is understanding goals, right? Understanding client goals. For some clients, it's, we want to make this go away as quickly as possible without giving up more rights than we need to, right? For others, it's, we want to make this go away quickly, but we also want to make it go away privately without, say, a public consent order or being under a probationary period. Maybe they're trying to go through a transaction to sell their license when you could easily sell your license in Maryland, which isn't the case right now. So I think the client interview, the initial conversation of what are your goals, and then also a bit of education in that interview process to say, you told us your goal is this, but if we go down that path, playing it out, right? Like going through all the moves on the chessboard, so to speak. So I think that's something that I'm really glad you hit on, because sometimes if someone says, I just want to make this go away quickly, they're not thinking of what making something go away quickly or cheaply looks like. Obviously, not trying to spend more money than we need to resolve a problem, but if you make it go away quickly and inexpensively on the front end, that can lead to making it last a lot longer and being more expensive on the back end.
Yep. I agree with all of that.
So we've talked a lot about kind of reactionary counseling, right? Something bad happened. And so how are we going to get you out of this pickle? But another thing, an aspect of your practice that I think our clients have benefited from tremendously is how can we, I don't like to use the term litigation proof because that suggests that you're proofing from any possibility of litigation down the road, but it's litigation insulation or assisting to insulate from unnecessary or kind of frivolous litigation, so to speak, if possible. Can you talk a little bit about what that aspect of your practice looks like and maybe some of the work that you've done with cannabis industry clients on that side?
Yeah, absolutely. So I think, the enforcers recently are very emboldened, and it's almost like they're looking for violations, which is sometimes hard to insulate from. But I think one particular area that I think you can take affirmative steps to insulate from is antitrust violations. And I bring that up in particular because I've helped and trained a number of cannabis clients at every level in the distribution chain, as well as trade associations, on the antitrust laws, antitrust compliance, and ways to avoid, um, you know, being assessed with an antitrust violation, namely because we were talking about, $1,000, $5,000 penalties for some of the cannabis regulation violations, but antitrust violations carry significant penalties, some as high as $10,000 a day, $10,000 a violation, and they can escalate. And I think that the at least various state attorney generals and state antitrust divisions with the current administrations and the federal administration have an eye on antitrust at the moment. So everyone is looking for various violations to assess. So we offer, a 1 to 2 hour training to teach sales employees, managers, every single level, just here are what the antitrust laws are. Here's what you can and cannot say to competitors. Here's what you can and cannot say to retailers. Here's what you can and cannot say to any level of the distribution chain. You cannot talk about price with any competitors. You cannot share certain information. And I think people are just kind of naive to that area of law. They don't, they think, well, why can't I tell them that they have to sell my very coveted flower for this exact price? If they don't do that, then my product is going to be deteriorated. But in certain states, such as Maryland, there are very, very strict laws that prevent you from telling a distributor or retailer how much they can sell your product for. And that is something that the antitrust division of the Attorney General's office looks for very closely, specifically in the cannabis industry, because it's new and they want to make sure everyone is following all of the various laws to a T.
Yeah, and just I think folks know this, but when we talk about antitrust violations, I think the state would tell you what they're trying to prevent against is anti-competitive behavior, right? So unfair competition against your competitors, price fixing, tying product sale. We'll give you this product, but you also have to sell this product along with it, or we're not going to give you anything at all. I think there's a lot of different examples of what we could be talking about, but generally when we talk about antitrust type activity, that's largely what we're talking about. I think with the remaining time, and by the way, as always, I should have mentioned this earlier. If you have any questions, feel free to drop them into the Q&A, and we will absolutely get to them. But barring that, one thing I want to go back to, we went from talking about reactionary counseling to proactive counseling. I want to go back to reactionary counseling for a second, and specifically around the issue of consent orders. So, I think, Kaylee, one of the things that you and I have certainly worked on over the years is this concept of disciplining of licenses, right? And in our in our business, in this space, some people don't believe us when I say this, some of the most valuable assets that our clients have are the licenses themselves, right? And when you have active regulators like we do in many of the jurisdictions in which we practice, disciplining of licenses can really be the death knell of a business, even if they're not doing anything intentionally wrong. I wonder if we could spend a minute on just talking about some of the approaches around negotiation of consent orders and what we've sought to do for clients there.
Yeah, I think I touched on this a bit, but I'm happy to go into more detail. I think this is also where that initial client interview comes in very handy, right? Because to avoid a discipline or a sanction on the license, we can say we're willing to increase the fine, or we will do a longer probationary period. And I think that there's a lot of ways to frame it to the negotiating party on the other side, which in Maryland is usually the state prosecutor for the Cannabis Commission, to say something along the lines of like, are you really gonna, I'm willing to be on probation. I'm willing to say that I will not commit another violation for so long, or I get hit with both, to show that I am committed to compliance and I'm committed to following the letter of the law, even though this was an inadvertent violation. Let's work together to try to figure something out so that my license isn't sanctioned. And I think that that's a real key to the negotiation, is to try to see what the client really wants, and kind of what's the state's goal. So sometimes the state's goal is just to, it's a money grab. They want to try to get additional fines. Sometimes it's to, showcase, like you said, a consent order. So they might want to have a good language in there about a violation, but they don't really care about the actual sanction. Sometimes they care about the sanction, but they're willing to make it not public. It kind of just depends on what you need, and knowing the various ways to negotiate it and the various things that the state is looking for, I think is a powerful tool in trying to reach the best result for the client.
Yeah, and I would just add on to that, beyond the issues and the tactics, one of the things that I think you would, whether you're engaging us or other counsel out there, you want someone that has experience with the AG's office. Understanding the issues and the rules seems like a foregone conclusion, but again, one of the reasons that a lot of us utilize Kaylee's services, and a lot of our clients utilize Kaylee's services because of the active relationship she has within the AG's office. So I think that's something that's important as well. So I don't see any questions in the chat, so I'll give folks another minute or two to do that. But while we're doing that, I just I did want to say thank you so much to those of you who have been with us for multiple of these for these sessions. They will all be available on our practice group page. You should look out for an email with a link to this recording and links to our other recordings. And I would just say, we wanted to have this kind of quick hits series. So it's not just another article that you need to read and digest, but something that's a little bit more interactive. But down the road, if there's topics you're looking for coverage on, if there's content formats that you think would really lend themselves well to these discussions, please feel free to reach out to me, to Kaylee, to any other member of our cannabis law team here. And again, just wanted to say thank you so much for your time and participation. And we certainly look forward to hearing from you soon. So with that, we will sign off and say have a good afternoon.
Thanks, Jonathan.
Thanks, Kaylee.